For those of you who don't know me, my name's Alex Nicol. I'm a principal lawyer at Aitken Partners in insolvency and commercial litigation. So thanks very much for joining us this morning. I've got Stephen Dixon with me, who's a partner at Hamilton Murphy, and he's got over 20 years of experience in both commercial and personal insolvency. So the two of us today will run through some of the issues facing businesses at the moment and the mechanisms around those. So I'll shortly hand over to Stephen to give the accounting viewpoint of the solvency and insolvency options available to businesses at the moment. And then I'll run through some of the legislative changes and legal issues that arise following that. So with no further ado, I'll hand over to Stephen Dixon. Actually, sorry, before I do hand over to Stephen, just from an administrative point of view, if any questions arise along the way, don't hesitate to click on the chat button at the bottom of your screen and write any questions in there, and we'll deal with them probably at the end of the presentation. But as soon as a question occurs to you, just type it through in the chat and we'll answer it at some point. Thanks very much.
All right, thanks, Alex. For those, as Alex outline, just to give you background, my name's Stephen Dixon. I'm a registered liquidator and a registered trustee in bankruptcy, and I've been working in the area of insolvency now for over 20 years. The purpose of today's webinar is to provide you some background in relation to some options available to you. As part of those options, it will obviously be a legal component to it, which Alex will talk you through. But it really is to give you an outline of some of the options you may need to consider at some stage down the track, or if you're an advisor, something that you can just provide a little bit of background to your clients in assisting them going forward. Anything obviously involving accountants, we'd obviously, as at Alex's firm, my firm, we would work with those parties in coming up with an outcome for your clients. There's two parts to my presentation today. One is the formal insolvency, corporate insolvency side of things, and the other one is the informal side of things. What I'll do briefly is firstly go through the formal side of insolvency. The current options available to any director at this point in time is either voluntary administration or liquidation. The voluntary administration process, which you're probably all well aware of because we've got a very live example, large one at the moment, in the form of Virgin Airlines. That's a process that generally can last for 25 business days. It allows the director to put the company into a moratorium period, basically allows an independent party, i.e. a registered liquidator, to review the business, its financial affairs. And as part of that process, you have quite wide-ranging powers to change or alter the business. If you need to, change supply contracts or renegotiate supply contracts, renegotiate leases, also look at the employee structure and make employees redundant if that's what's determined. So it's actually quite a useful tool in restructuring a business. The issue is, look, with any formal insolvency, obviously the creditors are aware of what's going on. There are 2 meetings of creditors that need to be convened. The first in 8 business days to confirm the appointment, but the more important one is in 25 business days, where effectively the directors have, the creditors have 3 options. The first is for the company to enter into a deed of company arrangement, i.e. a compromise of creditors' claims. The company can be placed into liquidation, or alternatively, the company can be returned to the directors if it's determined the company's solvent. That last option is fairly rare. The more common option that I'm dealing with is company entering into a deed of company arrangement. So therefore, after the restructure process, it can continue back in the hands of the director, just with a compromise of the creditor's claims. What I have done recently with one of my administrations is actually put it into what we call a holding deed. So what we've been able to put forward to creditors is that let's restructure the company to a certain degree, put it back in the hands of the directors for a period of 3 months. Once we actually come through this COVID crisis, for want of a better word, in 3 months' time, convene a another meeting of creditors to actually determine what we believe ultimately will be in their best interests, and also what we believe will be the return to creditors. Because at this point, there's been a massive impact on the value of assets, i.e. plant and equipment, land and buildings. There's a lot of unsurety out there. We're not exactly sure where we're going to end up. So what we were able to do on that particular occasion is to suggest to creditors, and they voted for that and confirmed they believe it was the right thing to do, was basically to put the company back in the hands of the directors. So you effectively put a moratorium in place for the creditors while we allow the company to continue for the next 3 months, and then go back to the creditors in 3 months' time with more of a concrete plan and more of a concrete position in relation to the asset values. So therefore the creditors know exactly what to a degree, what they're likely to receive and the likely outcomes. Plus, the other thing is, by putting the company into a holding deed, it allows it to continue to receive JobKeeper. So once a company goes in liquidation, it no longer qualifies for JobKeeper. The government has said if the company goes into deed of company arrangement, it allows JobKeeper to continue. So this is a holding deed is something that in my industry was spoken about in the past. It really is something that hasn't been utilised. So this process, or the COVID crisis, has allowed us to actually implement what we call a holding deed. The other example I've got in relation to a holding deed with this particular entity, it owns a property. We have had an independent party come in and look at the property and suggested that if we're able to find someone to sublease part of that premises, we will then underwrite the value of that property, and then at that point we take it to the market. So again, by putting the company into a holding deed, it gives us time to explore what we can actually do with that property, find a potential tenant, and then again, that will underwrite the asset value and then provide creditors with more surety going forward. So this holding deed, even though it's something that's been bandied around in our industry quite a bit, you can actually now see it working as we work through this pandemic, and as things become clearer over the next few months, it actually gives creditors some surety that they're at that point in time, we can give them more surety of what their likely return will be and the likely outcome will be for the company. So that just shows you some flexibility we have in restructuring the company.
And Stephen, just to interject there, one of the important aspects to remember is that voluntary administration is designed to keep the company alive.
Correct.
It's not essentially equivalent to a liquidation. So it is designed to keep the company alive and have a future after the voluntary administration process is completed. So that's important to remember.
Oh, 100%, Alex. That's right. The voluntary administration process was actually, just to put in perspective, was set up by the government back in 1993 to help businesses, basically about giving the ability to restructure and continue going forward. And that's the most important element of the voluntary administration process. Is exactly, and you're spot on, exactly why it was implemented. Now, without going into any great detail, I'll now go back to the second option available, and that is the liquidation process. As the word suggests, a liquidation process is basically shutting the business down, conducting a managed wind down of the business and assets, and then as part of that process, there is a formal structure by which we have to then distribute those assets to creditors. So effectively, employees come first, and then unsecured creditors are then paid after that. One of the things to remember with the liquidation process, it allows the entitlements, if there are outstanding entitlements and there aren't sufficient assets, the entitlements then will be picked up by the FEG scheme. And that's a scheme set up by the government many years ago to meet any outstanding employee entitlements should a company end up in an insolvency scenario. But to qualify for that, the company needs to be placed into liquidation. The only issue or area of employee entitlements that isn't covered by FEG is that of outstanding superannuation. That is still will be a personal liability of the director. But if we believe there is little hope of salvaging the core business, for want of a better word, the other option we have available is a liquidation process, but we can stagger that, and we can also stagger the wind down of the company, trying to maximise the return on those particular assets. And then therefore, after we've realised the assets, the money is then distributed to the employees, subject to any securities held by a bank. So the bank would have first effectively call on a group of assets called fixed charge or non-circulating assets. And then the employers would go first effectively out of cash and debtors, and then unsecured creditors, i.e. the ATO and other suppliers, would then be effectively last in relation to that payment of those creditors. Just one thing I will make very clear, there is a misnomer in the marketplace. The ATO no longer has a priority. They used to many, many years ago. They no longer have a priority over the assets of the company. They are an unsecured creditor like normal suppliers and normal, for example, leasehold creditors. Any of those creditors are all on the same level. The ATO no longer has a priority, but they do have other debt collection processes available to them, i.e. direct penalty notices, etc., which Alex will come to at some stage. The next area I just wanted to touch on was that with respect to personal insolvency. We're seeing at the moment in my particular firm an increase in personal insolvencies. So this is where an individual have provided, for example, personal guarantees, or they've incurred other debts on a personal level, and they want to deal with those. Just to give you a feel for personal insolvencies, in the last month, over 700 people entered bankruptcy in Australia. So, and I can tell you from first-hand experience, we've seen an increase in the number of people coming to us for personal insolvency advice because they're concerned about their personal positions. The options you have available with respect to personal insolvency are really three. There's something called debt agreements, which was set up by the government a number of years ago purely for people with credit card or small debts. So the threshold there is for $118,000. So if you've got debts of less than that number, you can put an offer to your creditors, and you have to do that through what's called a debt administrator. But it is an option available to people who really have credit card / gambling debts. That's what those particular arrangements were set up for a few years ago. The things that, two options that really are available with myself are debtor petitions. So that's where the individual basically petitions their own bankruptcy. Up until recently, an individual can be made bankrupt by a creditor through issuing proceedings through the courts. But at the moment, really the main option available are debtor petitions, where the individual basically says, look, I believe I'm personally insolvent, I can't meet my debts, I therefore want to go bankrupt. That process lasts for 3 years. It's a process where effectively we take control of their affairs. The main asset generally people would have would be equity in a property, so we would be entitled to that equity in their property. If they hold the property jointly with another party, would be only entitled to the proportion that that person owns in that property. You're entitled to a car worth about $8,000. Superannuation is not touched as part of a bankruptcy scenario. It also disqualifies that individual from being a director of a company for the period of time they're bankrupt. The other thing we're seeing more and more of is that in that 3-year period, an individual can actually propose a compromise of their creditors, similar to a deed of company arrangement for companies. That is then put to the creditors of that individual. If that is accepted, their bankruptcy is actually annulled, and that's a very, very important feature, because if it's annulled, it's as if it never took place. Therefore, it comes off the individual's credit history. It also allows them to become a director again immediately once that particular proposal is voted on by creditors. So it actually is a very, very powerful tool, and it also cleans up the person's credit history, and it allows them to go and apply for finance once again, and they actually do not have to disclose to that party that's going to provide them credit that they've been bankrupt. So we see a lot of my clients now proposing a composition to get them out of bankruptcy within that 3-year period. You can propose a composition anywhere in that 3-year period. It just needs to be, the return needs to be better than bankruptcy, which therefore provides creditors with a better return. Just to give you some feedback in that regard, I've been a trustee since 2008. I've only had one composition fail in that period. So you can take it on that basis that by far, if there is a composition put forward, it will be accepted by creditors. The other option is what's called a Part 10 arrangement, where you do not enter bankruptcy, but it's an arrangement under the Bankruptcy Act. So you avoid bankruptcy, but you put a cents on the dollar deal to your creditors. That has to be accepted at a meeting of creditors. It requires a special resolution for it to be accepted by creditors. The issue there, though, if you enter a Part 10 arrangement, it will sit on your credit history for up to 5 years, so someone will see it if you've entered a Part 10 arrangement. And the other thing is you cannot be a director for the period of time you are subject to a Part 10. The Part 10 the controlling trusteeship period of when you want to enter into Part 10 is a period of effectively 5 weeks where we take control, we conduct our own investigations, we send out a report to creditors, and therefore we convene a meeting of creditors with our recommendation for if creditors want to accept that Part 10, or if they want to, or if that fails, then effectively that's an act of bankruptcy, and then a party can then petition the bankruptcy of that particular individual. So really, at this point, there are 3 options available to the individual. It's just probably the most likely option that we're seeing people utilise at the moment is debtor petitions, because it allows them to put forward a composition, and therefore it helps clean up their credit history going forward. The other area that's available to companies right now is that area of safe harbour. That's an informal arrangement which doesn't require, when I say informal arrangement, it doesn't require ASIC or other parties to be notified that directors have chosen to go down the area of safe harbour. Why would you choose safe harbour? Basically, you choose safe harbour when a company is approaching an insolvency or heading towards an insolvent event. The issue with safe harbour is one that it provides effectively a protection mechanism for directors, particularly in relation to insolvent trading, and that's somewhere where the government have adjusted that legislation in recent times, but Alex will touch on that in more detail shortly. It also provides a level of protection in relation to the other obligations or duties of a director. It allows, in my view, safe harbour really should be considered for larger private companies or small listed companies. So it's not something that I would really recommend to a small mum and dad type entity, for want of a better word. I really would recommend it more for a larger private company or a small public company. It's something that has, again, I haven't seen widely utilised in recent times. However, it's something I believe through this process will be utilised more and more. How does safe harbour work? Basically, there's a number of steps in relation to safe harbour. First of all, you've got to come up with a restructure plan. That restructure plan needs to show that it's going to provide a better outcome for stakeholders than liquidation or administration. So the directors would then, with an appropriate qualified person, basically make an assessment of the likely restructure plan against liquidation or administration to show that the outcomes are going to be better for those stakeholders. As part of that restructure plan, you need to have specific documented goals and plans with clear timeframes. So as part of the legislation, safe harbour allows for a reasonable timeframe. It does not allow for an endless period of time. So therefore, it's very important in your documented plan that it provides for specific goals, and the plan is very clear. And as part of that, you would need to review your plan probably I would suggest on a monthly basis through a board meeting and a meeting of senior executives. So therefore, the plan is constantly being monitored. And obviously, as part of that, you would need to make sure you've got adequate reporting with respect to financial and other key KPIs to make sure then you're actually able to assess that plan, reconsider that plan, and adjust that plan as needed. A couple of key elements in relation to Safe Harbour: you're not allowed to have any ATO debt. You need to have your lodgements up to date, and you need to ensure that you can pay your entitlements as they become due. And so there's two very important elements in relation to if you want to enter Safe Harbour. One is no ATO debt, and the other one, the ability to meet employee entitlements. The other issue you need to be aware of in relation to Safe Harbour plan, excuse me, is you're having a qualified responsible person. Then generally that is a registered insolvency practitioner that basically assists you with that, oversees the plan, and provides that independent third party that then can be relied upon as part of that plan, particularly when you're considering any issues of breaching of directors' duties. So again, Safe Harbour is certainly one of the options that I see on the table now compared to, say, 12 months ago. It should be considered for larger, as I said, businesses, privately owned businesses, and say smaller public companies. Obviously, I can provide you further detail on that as if you need it. The other thing that obviously people are considering at the moment, or directors are considering, is basically the informal process. What we've done in recent times in my business is help CFOs and CEOs prepare three-way cash forecasts, look at their actual business plans, look at the structure of their products, their supplies, look at margins. In recent times, I've been helping out a company in the wood industry. We've been looking at all their different products. They have a wide range of products. We're actually able to have a look at the individual products, determine where the better margins were coming from, where there were certain products where they were low margins, and obviously also they were holding onto the stock for a period of time. So we basically revisited their product mix to assist with those, with its overall profitability, or assist with the company returning to profitability. So what we're spending a lot of our time on at the moment is also informal aspects, because of there's certain changes, as Alex will go through again, in respect to insolvent trading with JobKeeper. So people are asking us, directors are asking us to have a look at from the informal perspective to see what can occur prior to looking at any formal insolvency event. The other thing we've
Sorry, it looks like we're having some technical difficulties with Stephen there. Is he frozen for you as well, Andrew?
Yes, he's frozen. So perhaps we'll switch on to you, Alex.
He's also, I'm Joseph. Hi, how are you? Yes, he's also frozen for me.
Thank you.
Thanks very much for that, guys. Andrew, I might get you to run and update Stephen as to what's happened there, and while I continue.
That means the slides won't move.
That's fine. I've got at least a couple of minutes of stuff to get through before you need to change the slides. So, one of the things I wanted to say that sort of follows on from Stephen's points a moment ago is that while the Safe Harbour provisions are probably best utilised by larger private companies and smaller listed entities, some of those steps that you'd undertake for a Safe Harbour provision are extremely viable at the moment, and all businesses probably should be contemplating those sorts of steps, which are really around understanding the position in a detailed way, understanding the outcomes that might be achieved by any form of restructuring, whether it's an informal process or a more formal process, and going to see qualified people. And I'll touch on the importance of advice from various sources later on in my presentation. The first thing I want to touch on that many of you might be aware of is the changes to the legislation that the government's instituted to try and help businesses at the moment. And statutory demands are the first I'll touch on. And they're a very commonly used tool by creditors essentially seeking to enforce a debt that's owed to them by a debtor company. And there's a serious risk of being wound up if those demands aren't complied with. And one of the things that the government has done in that regard is increase the minimum debt required for a statutory demand up to $20,000 from $2,000, and the minimum time for compliance from 21 days, which is obviously a very short time frame, up to 6 months. So that's giving some leeway to businesses in complying with statutory demands, and it's an important relief valve given the current coronavirus affected situation. So while it is an important step, I just wanted to reiterate from a legal point of view that the debt, irrespective, will remain owing by the company, and the availability of the option to in fact issue proceedings in a court of law to recover that debt still remains. So while the statutory demand provisions might be delayed somewhat, there are still mechanisms available to a creditor to issue proceedings against that debtor. And the other thing that to bear in mind is, of course, if a creditor does issue a statutory demand, even though it's a 6-month time for compliance, purely issuing a statutory demand may have implications on compliance with facility agreements and covenants with financiers and other contractual arrangements with suppliers and the like. So there are things to bear in mind, irrespective of the timeframes and limits being increased. I've also noted their bankruptcy notices, which are essentially the personal insolvency equivalent of a statutory demand. So the time limit and the minimum amount to be issued to an individual in respect of a debt have also been increased and provided the same relief by the government. The second and important mechanism that the government has introduced is essentially a moratorium or safe harbour against insolvent trading, provided that the debts of a company have been incurred in the ordinary course of business. And anyone who's a director listening will probably be aware that there are provisions in the Corporations Act that allow personal liability for company debts to be pursued by a liquidator. And that moratorium or safe harbour has been introduced by a new legislative provision, which you'll see on the screen. The difficulty with this is the definition of ordinary course of business, and it's a bit unclear from the legislative changes what that actually means. And every director should, of course, bear in mind that, again, the deferral of those sorts of liabilities doesn't remove the company's responsibility for them. It merely removes the potential personal liability for those debts. There's limited judicial guidance from courts around Australia about what these sorts of provisions will mean, but we can be fairly sure that anything approaching dishonest conduct, for example, the concealment of material facts from suppliers or financiers about the financial position of the company, will mean that you can't avail yourself of these protections. Realistically, I think it's sensible for all directors to still adopt what would be the usual approach under the safe harbour provisions that have been in operation for some time prior to the coronavirus situation. And that's to develop and maintain a restructuring plan, importantly with someone appropriately qualified assisting you with that. And obviously the consideration that Stephen went through a moment before, that restructuring plan is reasonably likely to give a better result than any formal restructuring under an administration or liquidation. And those sorts of actions, the taking of steps and getting appropriate advice, are going to be a key factor in determining whether the court interprets any dishonesty to the conduct in incurring debts. The other thing I wanted to highlight in relation to insolvent trading is, while there is that relief from personal liability, directors are still under all of their ordinary law obligations under general and statutory provisions. So while there may be some protection from insolvent trading liability, the usual obligations of acting with due care and skill in the best interests of the company, avoiding conflicts of interest, all still apply. And if breach can result in serious prosecution, whether by ASIC or by a liquidator after the event. And I just want to raise that in certain circumstances where a company is experiencing financial difficulty, there may also be an obligation to keep in mind and have due consideration to the best interests of creditors. Really, the key I wanted to emphasise here is just the importance of understanding the financial position of the company, which is no different to the ordinary commercial situation, but becomes increasingly important in the current climate and when companies are experiencing difficulty, and communicating openly and honestly with all of the key stakeholders, which is everything from your financiers, landlords, key suppliers. And obviously most businesses will be engaged in pretty extensive negotiations with all of those parties at the moment. And it's really, really key to be communicating openly and honestly with them. Another aspect of the law I want to raise very briefly, which touches on some of the voluntary administration questions that Stephen addressed, are ipso facto clauses, which are essentially contractual provisions which provide that a party to a contract will have an automatic right of termination where there's an insolvency event, and they're pretty common in construction and other contracts. Reforms that were introduced a couple of years ago restrict the enforcement of those automatic termination clauses where you engage in some sort of restructuring scenario, including a voluntary administration. It's crucial to be aware of this potential benefit of engaging in a voluntary administration process, particularly when you're in some sort of distressed situation, whether it's a distressed construction project or otherwise. And the number one thing is to seek advice from an appropriately qualified insolvency lawyer or accountant as soon as possible to consider whether that option might be available to you. I also wanted to touch on director penalty notices, which Stephen mentioned a couple of times. For those of you who aren't aware, a director penalty notice allows the Commissioner of Taxation to make directors personally liable for certain forms of tax. Historically, that's been PAYG and superannuation guarantee charge. But from the 1st of April this year, that was actually extended, which has been mooted and debated for some time, but commenced on the 1st of April. And that's extended to GST, wine equalisation tax and luxury car tax. To make a director personally liable, the ATO needs to issue one of these director penalty notices. And the director will have 21 days from the issue of that notice to do usually one of three things, but there's a slight difference between two types of director penalty notices that I wanted to make sure everyone was aware of. There are lockdown notices and non-lockdown notices. And a non-lockdown notice is where a certain type of tax hasn't been paid, but has been appropriately reported to the Commissioner of Taxation. And in that circumstance, the notice will say that a director has one of three options, either to cause the company to pay the tax or pay it himself or herself, to appoint an administrator or to appoint a liquidator. And each of those things will avoid personal liability for the director. In the case of a lockdown notice, that's occurs where tax has not been paid and also not been reported on appropriately within the time frame specified by the ATO. So we've had circumstances where, for example, superannuation guarantee charge super payments were missed the deadline by 2 days, and then the tax office takes steps relatively promptly to issue notices that cause that liability to sit with the director personally. And even when the super has been paid to each of the respective super funds, that debt, as most people know, as soon as the ATO sends a notice, that debt is due and payable. And even though it's been paid, you'll have to run through what can be a time-consuming and expensive objections process with the ATO, which, given if it had been paid 2 days earlier, it would have been avoided, is a pretty severe step to take that can cost you tens of thousands of dollars to run through that process. So I just wanted to make sure that everyone was aware of the new introduction that you're potentially liable for GST. It's also important to be aware of if you are either contemplating joining a company as a director or exiting as a director. A director joining a company has 30 days leeway to consider the tax position of the company, and after that time will be potentially held personally liable for any tax debts of the company. So it's important, and we'd certainly recommend understanding the complete position of the company well before accepting a role as a director. And by the same token, if you're exiting as a director, you can still be held liable for debts that are owing for the course of your employment and engagement as a director. So it's important when you are exiting to make sure that you understand and ensure that all ATO liabilities are brought up to date. So more generally, I wanted to move on to just an underlying thing to everything that Stephen and I have spoken about today, and that's the importance of advice. Obviously, we're in a pretty unique situation at the moment, and all businesses are dealing with a whole range of different issues. And in any sort of distress scenario, it's really important, but the current circumstances even more so demand a really flexible and innovative group of advisors, and it's never going to be just one person that you're going to have to rely on. I know accountants play a crucial role, but given the current interplay between employment and OH&S issues that Stephen's touched on, and reduction of hours and wages with some businesses, people working from home and the issues that arise with that, leasing and landlord law and renegotiating contracts with suppliers, and all of the insolvency and corporations law issues that I've raised. It's really a unique maze that businesses have to work their way through, and the only way you're going to do that is by being on top of the financial situation of your own company and taking appropriate advice on all of those issues. And just to conclude with some summary about the current climate, obviously there's a whole host of government support out there, and businesses are taking advice and taking advantage of those situations. It's important to be aware that a lot of that assistance is realistically by way of deferral rather than complete relief, and that a company will still be liable for a lot of that deferred debt when September comes around or some other time comes around where those debts will become due again. So it's really highlights the importance of medium-term planning right now, and keeping in mind what your working capital requirements are and what your legal and accounting requirements are, and assess whether there are funding options, whether there are restructuring options, from an informal advice arrangement to some of the more formal restructuring options that Stephen's run through this morning. So we just emphasise the importance of getting experienced advice and really considering what the position is very early, rather than waiting and simply going into hibernation and then reconsidering at a later date. You really need to be considering what to do right now. And that's all I wanted to touch on this morning. I don't know if we have any questions or queries along the way, Andrew, that are directed to one or both of Stephen or I.
Can I just add one other thing in relation to the current climate? The other thing I've seen also in the last few weeks, the climate has changed completely with relation to debt and the raising of debt. The complete landscape has changed in that regard. I think what you'll see ultimately is when you come out the end of this, you need to be very, very alert to your working capital requirements and where your working capital is going to come from. Banks and other financial institutions are currently reviewing not only their current books, but LVRs they're going to borrow against properties. I've seen examples where that's now being dropped down to 55 to 60% of the value of the properties. They're obviously revaluing properties. So the whole gambit of finance is changing. The other thing that I've been alerted to is that very few parties will provide second mortgages going forward, and that's a reflection on what they believe property values are going to drop to. So the market in relation to debt has changed, will continue to change. I'm also aware a lot of financial institutions are currently reviewing their credit policies literally on a daily, if not weekly basis. So when it comes to moving your business forward, please have a look at your working capital requirements and consider that in advance, because as I said, that market has changed significantly in the last month. And that's what directors may also need to be alert to.
Thanks, Steve. We do have two questions, and they're both about safe harbour, so you may as well stay on, Steve. So Joseph wants to know about, in relation to the acquisition of a company and how the acquirer may enjoy the safety of the net, just after a little bit more information around those issues.
Sure. So I assume the question centres around they've acquired a company. It's obviously then the circumstances have changed very quickly. Again, in my view, is you'll be able to utilise Safe Harbour on the basis that you've identified the company hasn't gone into an insolvency scenario, but is heading towards that. So you would be able to use that. I think you need to be alert to make sure that you've got accurate records. So the books and records are up to date. You can determine the financial position. You can then sit down and look at effectively what you've acquired, what's changed, come up with a restructure plan. So I think if you have acquired a business or a company, I certainly think you'll be able to utilise Safe Harbour. It's just a case of implementing early, identifying the issues, identifying what's changed, and therefore coming up with a plan. But I do emphasise the plan will have to be reviewed constantly and changed constantly. And the other issue to bear in mind, it cannot be used for an endless period of time. So the plan needs to incorporate, it's going to go for 6 months, 12 months, whatever that time frame will be. That's got to be part of the plan. So it can't be just something where you can rely upon it for an endless period of time. But if you have acquired a company, I have no doubt you will be able to utilise those Safe Harbour provisions.
I actually just, thank you for that, Stephen. I just wanted to just extend the scenario by saying, rather than acquiring the company, but considering to acquire the company that might be in an insolvent or challenged position, can we then say, okay, we will acquire the company on the basis that we will consider the Safe Harbour provisions to give us that sandbox time to restructure and then keep going?
I think you need to ensure it's not insolvent at the time of...
Okay. Yeah, okay. So the insolvent issue is not precluded at the time of consideration. Okay, right. You've answered it.
Okay. No problem at all.
Yep, thanks.
Excellent. And our last question is from Bruce McDonald, which is with regards to an NFP, a not-for-profit, and can they seek Safe Harbour provisions?
Funny enough, I've actually given that advice 3 weeks ago to a party. Absolutely, they can. So the Incorporated Associations Act actually imports certain provisions of the Corporations Act, and yes, you can. I've actually explored that about 3 weeks ago.
Yep, spot on, Stephen. They'd certainly be in the same position, and they could certainly avail themselves of the same protective provisions.
So, yeah. So yeah, about 3 weeks ago, I've actually given that exact advice and provided a plan for an association.
Thanks, Stephen.
I should say, there's plenty of great resources out there. The Australian Restructuring and Insolvency and Turnaround Association has released various fact sheets and things like that for people who are experiencing financial difficulty, and we'll send around a link to their website along with the slides that we prepared today. And obviously, if anyone has any other questions that occur to them over the course of the next few days, don't hesitate to reach out to one of Stephen or myself. So thanks very much for your time this morning.
Thank you. Just one quick reminder to people, we will be sending out the slideshow from today as well, and the video will be up online on probably both the Aitken Partners and the Hamilton Murphy YouTube channels. We also have a seminar in 2 weeks' time, which came out of a session yesterday regarding business values and valuations when it comes to disputes and in, say, family law and compulsory acquisition, and at what point in time will the value of the business be locked away. So that should be quite an interesting discussion in a couple of weeks' time. Invites will be going out very soon. So thank you all for joining us, and yeah, stay in touch.
Awesome. Thanks very much all.
Thanks very much. Have a lovely day.